Welcome back to Lost Touch Channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. In this video, I'm going to discuss with you two cases for the price of one, and that price is free. After all of this time and all the knowledge that I've shared with you, my channel is still free to watch. So go ahead and subscribe and share it with others so we can grow this channel together. In this video, we're dealing with two cases that discuss robbery under California or Nevada law and whether robbery qualifies as a crime of violence under federal law, under the career offender or felon in possession chapters. So let's go ahead and discuss these two cases because they deal with similar topics. In this video, we'll be discussing United States versus Bankston and United States versus Edling. Now, both of these cases deal with a similar topic, but they're distinct cases. One interprets robbery under California law, and the other one interprets robbery under Nevada law. Now, both of these cases come out the same way, and they discuss whether robbery qualifies as a crime of violence under the career offender or felon in possession chapters under the federal sentencing guidelines. So it made sense for me to discuss both of them at the same time. So here's what happened. Mr. Bankston and Mr. Edling, in their respective jurisdictions in their district courts, pled guilty to felon in possession of a firearm under 18 U.S.C. 922 G1. Now, in order to determine how much time an individual is facing in prison after pleading guilty to this offense, we have to look at the federal sentencing guidelines. Now, the sentencing guidelines are not mandatory. They're advisory, which means that a sentencing judge has to properly and correctly calculate the sentencing guidelines before imposing any sentence. But at the end of the day, the sentencing judge makes all the decisions. He can give you more time or less time than what the sentencing guidelines say. And that's why it's good to have a good attorney in order to put some pressure on the court to give you less time than what the sentencing guidelines say. Now, to determine the base offense level or the starting point under the sentencing guidelines, we have to look at Chapter 2K2.1. This chapter deals with felon in possession statute 18 U.S.C. 922 G1. Now, I will put a link to the sentencing guidelines in the description under this video, and of course I encourage you to go and look at the guidelines because it makes more sense if you watch this video and also look at the guidelines. Now, the base offense level will depend whether the defendant has priors that are crimes of violence. Now, the term crimes of violence is kind of a term of art. It is defined in Chapter 4B1.2, which is also a career offender chapter, which means that if you have priors that are crime of violence, you can be enhanced in two different ways. Your base offense level can be enhanced under 2K2.1, felon in possession. And if you're also, let's say, charged with a drug offense, your career offender status can also enhance that status and make the base offense level higher in drug offenses. So these cases often, even though they deal with just robbery or only crime of violence, they touch on different topics in the guidelines. When we define crimes of violence, there's two clauses to the definition. People often refer to these clauses as elements clause or enumerated offenses. Under the elements clause, it says that the crime of violence has an element of use, attempted use, or threat of use of physical force against a person of another. Now, under enumerated offenses, a crime of violence is murder, voluntary manslaughter, kidnapping, aggravated assault, forcible sex offense, robbery, arson, extortion, or the use of unlawful possession of a firearm or explosive devices. Those are the enumerated offenses that are always crimes of violence. So when you first look at these definitions, you might say, if an individual has robbery on his rap sheet, if he has been convicted of robbery, well, robbery is an enumerated offense. But let's take a look. In Bankston, Mr. Bankston had a robbery conviction under California Section 211. Now, in Eadling, that individual had a conviction under Nevada Revised Statutes 200.380. But they're kind of similar, so again, this is why both of these cases come out the same way. So let's take a look at the definition. If we look at robbery under California law, it is defined as felonious taking of a personal property in possession of another from his person or immediate presence and against his will, accomplished by means of force or fear. Now, we have to now define the words force or fear. What does fear mean under California law? Well, fear of an unlawful injury to the person or property of the person being robbed. So wait a second. Under federal definition, we have to have an element of use or attempted use of physical force against the person. But under California law, robbery can be accomplished by a threat to property. It says here that it's unlawful injury to person or property, meaning that the definition is broader than what it says under federal law. And if it's broader, it is not a categorical match. So now let's take a look at the enumerated offenses. When we're talking about enumerated offenses, well, robbery is listed, but the definition of robbery, this is federal robbery. And under federal law, robbery always has an element of a danger to person. Again, California law does not require that. You can be convicted of California robbery, or in Mr. Eveling's case, Nevada Revised Statutes has the same definition. Both of these individuals could have been convicted of robbery by merely threatening property. How does that look like? Well, if I come up to somebody and say, hey, give me all your money or I'm gonna key your car. There is no threat to the person, but there's a threat to personal property. That is different than what the federal law says. So it does not fit under either of these clauses. Under the first definition, property is not listed, and under the enumerated offenses, we know that robbery is defined more narrow under federal law. Now, in both cases, they discuss whether robbery can also fit under extortion definition. But again, it cannot. In 2016, the federal sentencing guidelines were revised. And under the new definition of extortion, it specifically says that extortion means that there's force, physical injury, or threat of physical injury against a person. Property is not enough. So threat of property to property, merely threat of property, is not enough under federal law. And because of that, the Nevada Revised Statute or the California robbery under Section 211 are not crimes of violence, which means that the base offense level will not be enhanced. And if we're dealing with career offender chapter, it is also not a crime of violence under career offender chapter 4B1.2. So hopefully you now understand a little bit more about the Nevada statute or the California statute and how the federal law interprets robbery. And specifically, that robbery is not a crime of violence. How is this case helpful to you? Well, hopefully you've hired a good attorney, because in federal court, we're often fighting over the sentencing guidelines. If my client pleads guilty, or we go to trial and unfortunately he loses, well, in that situation, we're back to the guidelines. And there's going to be 3 recommendations at the end of the day. The prosecutor is going to say one thing, probation department is going to say another, and then your attorney hopefully argues something like this that helps you get your guidelines lowered. Hopefully you enjoyed this video. Please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.